Georgia. Not only are you a physician, you're not here speaking on behalf of physicians, you're here speaking on behalf of patients all across this country and defending them, and I appreciate the great fight that you're putting on and the resolve that you have for each of us as you're leading us here as Republicans here in the House. So thank the gentleman from Georgia. What he brought up as we go in the last 5 minutes here with Mr. Bishop, he brought up that the government right now taxes us on what we do or consume, but this is a first in which government can now tax you on what you don't do. That's an amazing concept. I hadn't really thought of it that way until Mr. Price brought it up. So now the federal government has moved into a realm which has never been in before, saying, hey, because you're not doing something, I'm going to tax you. So I'm going to determine what it is that you should be doing that you're not doing, so therefore I can collect a little revenue. Here we are today with something such as this. So, Mr. Bishop from Utah, yes.
Mr. Speaker. Mr. Speaker, I rise to file a conference report on H.R. 4348. Mr. Speaker, pursuant to Clause 7 of Rule 22, I present a privileged report.
Clerk will report the title.
Conference report to accompany H.R. 4348 to provide an extension of federal aid highways, highway safety, motor carrier safety, transit, and other programs funded out of the Highway Trust Fund pending enactment of a multi-year law reauthorizing such programs and for other purposes.
Order is printed.
Thank you.
Gentleman from Georgia may proceed.
Thank you, Mr. Speaker. As we were just wrapping this, I guess, spirited discussion here earlier, Mr. Bishop, you heard the progressives celebrating this decision today. And so what were they celebrating? What the federal government can tax you if you do something, but today's celebration was the fact that the federal government can tax you when you don't do something. So I appreciate you joining us tonight to give your thoughts from the great state of Utah.
I appreciate the gentleman for yielding me a few moments here, and truly this is a unique day. And I'm happy to join my comrades, or colleagues in talking about this particular issue. You know, the old cliche is simply Supreme Court decisions should not be confused with constitutional principles. Today we had a case brought by many states to the Supreme Court, and the administration had always said this Medicare, this Obamacare is not a tax, it's not a tax. Well, the court said today on 5 of the 9 decisions said, yeah, it is a tax, and I guess it's legal if you call it a tax. 4 of the 9 said that not even that's good enough, but nonetheless, it's a tax. And it's appropriate that we talk about that power of taxing because, you know, the most famous of all cases, McClintock versus Maryland, that was one of the major decisions actually made in this particular building, simply said the power to tax is the power to destroy. And we have that in front of us right now. I don't think we should have expected judges to do what legislative branch, in this case Congress, ought to do. And I think it's positive that we move forward in this effort to make sure that this program does not go into effect and we take concerns for our constituents and maybe even learn something from it. You know, the idea of judicial review didn't exist for the first decade and a half of this country. Marbury versus Maryland didn't happen until almost 15 years into the country. Washington, who was at the Constitutional Convention, always thought the veto should be what determined constitutionality, a kind of executive review, and Jefferson always said there should be legislative review. So I think perhaps our founding fathers thought all branches should be involved in that kind of concept, and I think there should be a fourth one added to it, which is the states at the same time who started this process in going to the courts. Like, we don't come on this floor often and quote anti-federalists because they lost. However, I want to today, because even though they were wrong on the Constitution, every once in a while they were right on some of the concepts. So in the 17th letter from a Federalist farmer, written either by Millington Smith or one of the Lees of Virginia, we always have, no one really knows who actually did it. He talked about this idea that the states, if we have indeed the concept of federalism, should have some power to do real things. He simply said, our people, I've heard it observed that our people are well informed and will not submit to oppressive government, that state governments will be ready advocates, But of what avail will these circumstances be if the state governments, thus allowed to be guardians of the people, possess no kind of power to stop the laws of Congress injurious to the people? One of the things they quickly said is states really don't have the concept or the power to actually involve themselves in this particular issue. There are some concepts that are out there. The repeal amendment, which is proposed by some legal scholars and has been proposed by some state organizations, would actually give a tool for states to be involved in this discussion because it impacts those states. Right now, they simply have to accept what takes place here in the rarefied air by the Potomac River. But if indeed we gave the states a tool, so if enough states were to band together to say, no, we disagree with this rule, we disagree with this regulation, we disagree with this law, we even disagree with this Supreme Court decision, the states would have an ability to add a new check and a new balance to make sure that the common people of this country have some kind of voice in these decisions. And I think one of the things we should learn from today's decision is that we desperately need another check and balance in our process to make federalism a realistic and real term, and that means to involve the states in giving them some powers to have real decisions. Not so they have to come to us as they have so far begging, but so they can actually have a say. I think we would be better off as a nation if we did it. This decision today, if nothing more, should add a resolve for us to solve a political problem politically, to do it here in the halls of Congress, but maybe add another player in this process, the states, so that they also have a say in this power to tax, which is the power to destroy. And I realize we're coming close to time. I want to give my good friend from Georgia the chance of giving the final word on this particular, and I appreciate his efforts to organize this opportunity to talk about what has happened today, so I will yield back to him.
Thank you, gentlemen. Thank you for your comments tonight and your great insight and reflecting back on early documents and early words that have been shared. And Mr. Speaker, as we conclude tonight, I want the American people to know that we are resolved to restore the liberty that was lost today through the full repeal of Obamacare. That will be our focus as Republicans in the House. Thank you, Mr. Speaker. Yield back.
Under Clause 8 of Rule 20, the filing of the conference report on H.R. 4348 has vitiated the motion to instruct conferees offered by the gentlewoman from California, Ms. Hahn, which was debated yesterday on which further proceedings were postponed. How'd I do? Pursuant to Clause 12A of Rule 1, the House stands in recess subject to the call of the Chair.
Today in the House, members voted 255 to 60